Is creating an environmental impact statement, or EIS, under the National Environmental Policy Act a one-and-done step for federal agencies? In Marsh versus Oregon Natural Resources Council, we'll see whether agencies are required to create a supplemental EIS after new information comes to light. Congress authorized the Army Corps of Engineers, or the Corps, to build 3 dams on the Rogue River Basin in Oregon. After 2 dams were built, the Corps began planning for the 3rd dam, known as Elk Creek Dam. The Corps completed and released its final EIS for Elk Creek Dam in 1980. However, after the final EIS was prepared, 2 new documents were created by the Oregon Department of Fish and Wildlife and the United States Soil Conservation Service. The documents raised issues about the dam's impact on turbidity, water temperature, and fish mortality. The documents suggested that the environmental impact of the dam could be greater than what was discussed in the final EIS. The Corps reviewed the documents but determined that it didn't need to create a supplemental EIS. The Corps proceeded with construction on the dam in 1985. In October of 1985, 4 nonprofit organizations, including Oregon Natural Resources Council, sued the Secretary of the Army, John Marsh, to enjoin construction of the dam. Among other claims, the nonprofits argued that the Corps violated the National Environmental Policy Act, or NEPA, when it failed to create a supplemental EIS to address the new information in the 2 documents. The district court denied relief. The nonprofits appealed. The Court of Appeals reversed and held that the Corps should have created a supplemental EIS. The Court of Appeals explained that the 2 new documents brought significant information to light and that the Corps failed to evaluate this information with sufficient care. The Corps appealed, and the United States Supreme Court granted cert.